Alaka couldn't be with us here this evening, so it falls to me to welcome you on behalf of Alaka, the London Shipping Law Centre, the Admiralty Solicitors Group, and the Admiralty Bar Group, and Ince & Co. I'd like to welcome the Chairman, the Honourable Mr. Justice Andrew Baker, who will need no introduction to you, and our panel. The title of our seminar this evening is the Admiralty Court, the new rules in CPR 61 and the recent decisions. I'm going to hand over to the Chairman, Sir Andrew, very shortly, but before I do so, I'd like to extend as well to you, after we finished, an invitation to join us for some drinks. I'm hoping the sunshine will continue. For those who are brave enough to weather the cold northeasterly wind, I think it is just about warm enough out on the balcony. But if not, then please do join us inside for some drinks afterwards. Anyway, that's plenty from me. I'll hand over now to our Chairman, Sir Andrew, to introduce our speakers and to conduct proceedings.
Thank you. Thank you very much, Chris. As at least some of you will know, I have attempted wherever possible to be a loyal supporter of the LSLC and its events. It's a particular delight to be invited, or indeed to have got them to invite me to chair an Admiralty event, not only hosted by or under the auspices of the LSLC, but in association with the ASG and the ABG. I will confess to have been not a member of the ABG whilst at the bar. I now wish I had been, and perhaps I would have had more of a wet practice before becoming the Admiralty judge. But my principal dealings with the ASG and the ABG since becoming the Admiralty judge in succession to Sir Nigel has been through the Admiralty Court Users Committee. And so in a sense, this seminar is also in a way under the auspices of the outreach by that Users Committee to publicise and I hope have a constructive discussion about the changes that we have recently made to various parts of the rules and practice directions relating to Admiralty matters. There's also, towards the tail end, a review of the recent decisions of the court, which always makes a chair in my position slightly nervous, because I note inevitably in relation to what is, in terms of a volume of work, ultimately a small-ish specialist list, that they are either my decisions or my predecessors' decisions. So we shall see. And of course, in the audience, there are probably at least as many winners as losers in relation to any of those decisions if you have been involved in them. But my main job tonight, so let me move on to that immediately, is to introduce, as if they need introduction to this audience, our speakers in what I hope I'm going to get right as our order of presentations. Then I'll simply hand over to them to pass one to the other seamlessly, and we'll host a question and answer session at the end. So we're going to hear first from Mark Jones from 36 Stone, known to many of you, I'm sure, as a very experienced and well-regarded Admiralty practitioner. He has been both administratively and otherwise substantively a driving force within the Users Committee in the process that culminated particularly in the most recent set of rule changes to which he's going to speak, relating to collision statements of case and the consultation process we undertook. Then more on that same theme from Darryl Kennard, these days of Penningtons, Manches Cooper, as they have become, and Alex Macinnes. Darryl and I know each other of old from times when he instructed me or was instructing my opponent whilst I was at the bar. I know him more especially of late as the man who has managed to settle the eternal bliss, so that eternal vindication of my judgment will have to wait. There we are. Alex, many of you will know, is one of those wonderful lawyers in which I think we, the maritime legal community, specialise perhaps more than any other, namely the lawyer as second career after a proper industry career first, in his case as a naval surveyor with Lloyd's Register. So between them, Darryl and Alex will give you a review of what we hope will be the practical impact and importance of some of the rule changes, as distinct from simply introducing them, and the thought process behind them, which will be Mark's job. Then, marking my and my predecessor's homework, we'll hear from Donal Keaney, another of those lawyers with the more interesting original background, 25 years experience in the shipping sector altogether, only the last 10 of which or so in the legal environment, senior marine manager these days here at Ince & Co. And then finally, she has said very briefly, but nonetheless importantly, on an aspect of the Admiralty Court's work which constitutes historically, or at least as a matter of recent history, something like 2/3 of our caseload, albeit caseload, the bulk of which has tended then not to stay in the Admiralty Court, as Sarah will no doubt be explaining. And that's Sarah Prager, who recently acquired the magic initials KC after her name, for which publicly I repeat what I've said privately, which is my most sincere and happy congratulations. So with that, by way of introduction or reminder from the material you may already have seen of those from whom we're going to hear now, I will hand over to Mark. Thank you very much.
Good afternoon. I have to warn you at the start, this is not really a gag-filled session, given that we're going through procedural rules. It's quite hard to slip them in. So on 1st of April this year, various changes came into force in respect of Part 61, its associated practice direction, and Form ADM3, the collision statement of case. So in summary, those changes concerned the expansion of the early disclosure of electronic track data in collision claims, and revisions to ensure the full and proper particularization of collision claims. Now, in the handout, just behind the bios, you'll find a document which sets out or summarizes the changes, rather than giving you a whole printout of the complete Part 61 and PD. These are just the changes. So the highlighted bits in yellow are the new bits, or highlight where deletions have been made. So these changes were quite some time in gestation. The possible need for reform was discussed at the Users Committee way back in 2021, I think it was, maybe even 2020. And then questionnaires were sent out to the membership of the ASG and the ABG, seeking input on what was essentially a blue sky, or any idea is a good one, approach. The end result, after much debate at the Users Committee, was a paper submitted to the Civil Procedure Rules Committee with various proposed changes to the procedures for collision claims. And those proposals were, by and large, accepted without any opposition. So I'll begin first with the change concerning early disclosure of electronic track data. So back in 2017, again at the request of the Users Committee, the rules concerning the early disclosure of ETD in collision claims were introduced. So ETD, such as most obviously the data on a vessel's VDR, are often, in fact, almost always nowadays, critical in a collision claim. So the 2017 version of the rules, you'll see there before the yellow struck out passage, required every party to disclose whether or not it had any ETD in its control after an acknowledgement of service had been filed. But there was then no obligation to provide early copies or permit early inspection at that early stage, unless all the parties involved had ETD in their control. So back in 2017, when this was introduced, that element of mutuality was felt to be an appropriate limitation and what is otherwise an unusual obligation to provide early disclosure. So generally, parties in English litigation in English courts provide disclosure and inspection after everyone has stated their case and not before. The law on applications for early disclosure generally make it clear that early disclosure is the exception and not the norm. So while early disclosure of ETD was thought to be obviously beneficial for the swift and efficient handling of collision claims, the mutuality requirement was thought to retain an element of deference to the normal procedure. In practice, however, the requirement of mutuality has made little difference. In almost all collisions involving commercial vessels, at least, both or all vessels are almost always going to have some ETD. Even if one vessel really does have nothing, it was usually not hard to get hold of some third-party data like AIS from a shore-based third party, so as to engineer satisfaction of that mutuality requirement. So the Users Committee proposed to ditch what was really a fig leaf of mutuality and embrace the early disclosure of ETD in full. And that was easily done. As you'll see, it simply entailed crossing out the condition where every party has electronic track data in its control. The second limb of the User Committee's proposed changes was more substantial and concerned the way in which the parties state their cases in collision claims. So with apologies for any unnecessary lessons about sucking eggs, in a collision claim, so-called collision statements of case in a prescribed form, ADM3, have to be filed at the Admiralty Court by both the claimant and the defendant within 2 months of the date in which the defendant acknowledges service of the claim form. Only after the last collision statement of case has been filed must each party then serve a copy of its collision statement of case on the other party. So the parties in collision claims must plead their case blind, as it were, without knowledge of what the other party alleges. So the origin for this mode of blind pleading, which is unique to collision claims in the Admiralty Court, seems to be a rule introduced back in 1855, requiring parties in collision claims to file what was then called the Preliminary Act. So the unique procedure has continued with relatively little change for more than 150 years. Indeed, the advent of the CPR didn't bring much change. It only really brought in a change of terminology. No longer could we call it a preliminary act. Now we had to call it a collision statement of case. So the function of a preliminary act was explained by the author of the rule, by which they were first instituted, the famous Dr. Lushington, in the Vortigern. So he said, preliminary acts were instituted for 2 reasons: to get a statement from the parties of the circumstances recenti facto, and to prevent the defendant from shaping his case to meet the case put forward by the plaintiff. So historically, the thinking behind the requirement to file a preliminary act was twofold: to force both parties to provide essential information about the circumstances of the collision without having the opportunity to frame their evidence defensively to meet the case set up by the other vessel, and to force both parties to provide that information while the incident was still fresh in the mind and before anyone's recollection could fade or be molded by subsequent review. So as I said, when we canvassed the views of the users of the Admiralty Court about current procedure, including this long-standing and unique procedure for pleading in collision cases, everything was on the table, including the abolition of collision statements of case entirely in favor of normal pleadings filed and served sequentially. And we got a lot of feedback, quite a lot of outrage in some cases, perhaps even more than one might expect. And there followed a lot of debate. There were some various issues that came up about the pleading of collision claims. The key problem and the key complaint was the unfortunate practice that had developed of pleading as little as possible in Part 2 of the collision statement of case, i.e. the part of the ADM3 that's more akin to a normal pleading. So often all that was done was to repeat Part 1, which is actually required, and then in effect state a list of unparticularized or barely particularized alleged generic breaches, such as failure to take care or failure to keep a proper lookout or failure to take avoiding action, really obvious ones, and then followed by a list of coal regs that had alleged to be breached, often just a list of numbers, some of which were on a kitchen sink basis, were thrown in just in case the facts turned out to require that collision regulation to be looked at. So that practice meant that the court and the parties were often left somewhat in the dark about the parties' respective cases. It was not uncommon, as far as I'm aware, for collision actions to get all the way to trial on the basis of two collision statements of case, neither of which refers to or responded to the other. So where matters proceeded in that way, the first time the claimant came to know the defendant's response and vice versa to the allegations of fault and causation made in the statement of case could even be made as late as when skeletons were served shortly before the trial. Of course, things could be inferred earlier than that from the exchange of witness statements as to what appeared in witness statements, or perhaps at case management conferences. But the court and parties shouldn't have to grope their way towards the nuts and bolts of the respective cases from correspondence and skeletons at CMCs and so on. The point of statements of case is to make the parties' case clear to each other and the court at an early stage. Interestingly, if you're interested in these kind of things, as I understand it, and I attribute this little bit of historical learning to John Kimball, who I think is with us remotely, which is to say that I blame him entirely if this is not true. Under the old practice, it was just the information in the preliminary acts, which then was defined as part one of what we know as a collision statement of case, which was only provided without knowledge of the other party's case. In fact, the rest of the pleadings, containing detailed allegations of fault and causation and so on, proceeded in the normal sequential fashion, claim, defense, reply. And then when those conventional pleadings were closed, the preliminary acts containing all of the recinti facto information, data, would then be disclosed. So if anything, the modern approach that had grown up was less conducive to the parties knowing the cases they had to meet and the court knowing enough to manage the case efficiently than the historical approach. The principle of pleading blind was, we discussed, to some extent qualified by the rules on the early disclosure and provision of ETD that came into force in 2017. So while it remained the case that each side pleaded simultaneously and in ignorance of what allegations of fault the other was going to make, the reality was that both sides knew much more than they used to about the navigation of all the vessels involved in the lead up to the collision when they came to plead the case. So one might question the need for, or indeed the benefit of pleading blind anymore at all. Of course, Dr. Lushington's objective of obtaining a statement from the parties, the circumstances recenti facto, remains a worthy one. Nowadays, the reality is that the collision statement of case is never going to be prepared at a time when the circumstances are fresh in the mind. On the contrary, the cases are replete with dire warnings to junior counsel, it's always junior counsel, about not settling a collision statement of case without all the information and statements to hand. Largely because whatever you put in part one of your collision statement of case is treated as tantamount to an omission. The goal of achieving fresh and reliable evidence is now met, in large part at least, by the fairly recent introduction of the Practice Direction 57AC and the detailed rules designed to restore the reliability of witness statements. In fact, just a quick aside, as another pat on the back for various of us in the room, I think it's probably fair to say that Admiralty practitioners have been the leaders on that front for years. The master mariner or junior solicitor's early attendance at casualties to take relevant and timely statements has always been a prime example of what and how it should be done. And we have a pat on our back for that one. Finally, and rather remarkably, the information that had been stated in the preliminary act in the 19th century, so the list of questions to be answered in that first part of the collision statement of case, was the same as that required in the CPR's version of a collision statement of case until April this year, 150 odd years later. Well, that's probably testament to the wisdom of Dr. Lushington all that time ago. However, it did beg the question, whether those questions should be updated. So where did we land? What were the changes proposed and made? So first, a couple of things that remained the same. The hallowed collision statement of case remains. There was actually no or very little appetite to go so far as to dropping the special way in which collision claims were pleaded. Nor was the basic principle of pleading blind dropped. The exchange of collision pleadings will still be simultaneous and not sequential. So what has changed? So the first element of the changes was designed to update the information that has to be set out in part 1 of the collision statement of case. So the old form had 16 questions and boxes that had to be completed. Rather than deign to try and fill it out, some of the questions set out by Dr. Lushington, even though some are perhaps of less relevance nowadays, the changes amount to an attempt to add to that wisdom, if I may say so, by adding an additional 8 questions. And you'll see those on the handout. I'm not going to laboriously go through them. They're on what's marked as page 2 and 3. All I'll say is that, broadly speaking, questions 7 to 22 have been introduced to reflect modern navigation equipment and the usual availability of VDR data and the like, albeit question 17 is of wider interest in any event, who was on the bridge. And then questions 23 and 24 were introduced in light of the relevance of whether a vessel is engaged in fishing or is a motor vessel otherwise restricted in its ability to maneuver to the application of the toll rates. Just as an aside, there was some debate about the appropriate periods applicable to various of the new questions. So you'll see some of them ask for information from C-30 to C+30 minutes. The user committee thought that 30 minutes before and after would do the trick. Apparently, Sir David Steele used to say that in most collisions, at least those in open waters with vessels underway, he was really only ever interested in what occurred for about 15 minutes before the collision. I was going to make some more comments, but I won't. Of course, in an appropriate case, parties can always seek disclosure of ETD for longer or different periods. So that brings me to the most substantial changes to the way in which collision claims are now to be pleaded in part 2 of the collision statement of case. So as I mentioned, it seems to have become the unfortunate norm to plead collision claims in a fairly skeletal fashion. So the essential mischief that results is the parties in the court don't have sufficient detail to prepare and manage the case efficiently and fairly. The surveys indicated any universal acceptance that the pleadings in part 2 needed to be significantly more detailed than is currently the norm. So the solution arrived at was to introduce rules to attempt to force claims to be pleaded in essentially the same level of detail as other claims in the Admiralty Court, or indeed in the commercial court. The objective is to ensure that part 2 of the collision statement of case should fully and properly particularize the party's case to the same level of detail expected of any other statement of case, in terms in particular of factual allegations and allegations of breach of duty. The objective will be achieved, we hope, by the introduction of the language designed to ensure that full and proper details of the party's case do indeed appear in part 2. You can see those changes in the handout. Where did I put them? Page 1, I think they are. Yeah, page 1 and 2. So you start in part 61, which includes the phrase that sends you to the practice direction, the details of what has to be included. And then in paragraph 4.2 of the relevant part of the practice direction, you'll see that the changes now require, yellow, full particulars of the sequence of material events leading up to the collision and all allegations of causative negligence. If you follow over the page, you'll also see that in part 2, so at page 3, you'll see in part 2 of the ADM3, the instructions that appear on the printed form have also been amended to follow the same rubric. So the phrase full particulars of the sequence of material events leading up to the collision is entirely new. At present, many collision statements of case contain next to no narrative or facts, simply repeating the data in part one. So this provision is designed to force a party to state its version of events. It is qualified by the word material, so it's not simply an invitation or obligation to tell the story in minute and unnecessary detail. The qualification of causative in respect of the allegations of negligence or other fault should also serve to focus the pleader's mind. We'd originally used the familiar phrase full and proper particulars on the basis that everyone knew what that meant, and it carried the right connotations as to the extent and degree of detail required. But the Rules Committee vetoed it. It's too old-fashioned and pre-CPR language. So we ended up with their preferred term, the basic full particulars. Anyway, essentially, the phrase is meant to connote the same level of particularity that one would expect to see in the pleading of any other case in the other courts. A quick aside as to what was rejected. Rejected an explicit requirement to state a narrative chronology of events leading up to the collision. That was considered but rejected because it thought to be too prescriptive. A requirement that the parties actually pleaded their cases as to alleged degrees of causative potency and blameworthiness, i.e. the key factors that are involved in an apportionment of liability. That was also canvassed. The idea being that people were trying to attach a label of, say, high, medium, or low to the various allegations. But again, the idea was rejected as being overly prescriptive and, frankly, expecting too much of the parties at the stage when they're pleading their cases. Another one that was considered but rejected was an obligation to attach annotated plots to the collision statements of case as a new part 3, in effect. Again, it was thought to be too prescriptive and in reality impractical at that stage of the case. But there was substantial support for a requirement that the parties do produce annotated plots at an earlier stage than they do at the moment. And I think that's going to get picked up on by Alex. I think he's looking at me daggers in case I nick some of what he was going to talk about. So the second part of the solution involved the introduction of an obligation on each party to plead a collision defence. Again, something new. That requirement we thought, fit well with the requirement for greater particularity in parts 2 of the collision statement of case. In respect of some issues, the pleader can simply admit or deny an allocation by reference back to that party's own parts 2, where they've set out their alleged facts. But other allegations made by other parties may require a freestanding response. Now, the first element of doing that, referring back to your own parts 2, may seem mildly pedantic, although it's hardly hard or especially time-consuming to do. But it seemed a small price to pay for ensuring, or hopefully ensuring, that the parties will have pleaded their respective cases on all issues raised by both parties or all parties by the time of the CMC. In addition, in reference to the content of collision defences, the usual rules regarding deemed admissions will now apply, as set out in part 16, which should ensure, we hope, that the parties engage with all pleaded issues raised by the other parties in part 2 of their collision statement of case. So those new rules you can find set out the collision defence on page 4 of that handout. So in part 61 itself, you have the obligation introduced in the timetable. And then in 45A, 4.5A in the practice direction, you find the details of what must be in there. That paragraph is modelled almost entirely on the requirements of a normal defence that are found elsewhere in the CPR. And it includes, at the end, subparagraph 4, that deemed admission proviso, which will be familiar from other cases. Then you have the rules for filing and blind filing, and then subsequent exchange of copies of the defences in 405B and 405C. Finally, there is an option to file and serve a reply. And again, all that will be done blind. And you can see that's done in those final paragraphs that are mentioned in that handout. That, of course, is optional. And then the very final change was a necessary consequential one about CMCs. The first CMC will now follow the filing of collision defences rather than the collision statements of case, which again follows the model of other cases. So that brings that to a conclusion. So essentially, it's not a revolution. No one quite had the nerve for that. More of an evolution. The users committee reckoned that these changes would greatly enhance the ability of both the court and the parties to identify the relevant issues at an early stage and then manage the case appropriately. The changes shouldn't cause the parties to a collision claim any undue difficulties, we thought. After all, they will hopefully simply bring pleadings in parts 2 of the collision statement of case into line with statements of case generally in the commercial court, while maintaining the spirit, at least, of blind pleading that has been a part of Admiralty Court procedure since the time of Lushington. I'm now going to hand over. So I think from Darryl, you're going to get a bit more of the history and the practical side of things.
Thanks very much, everyone. Mark's taken us through a very detailed summary of the changes, and whilst not full of gags, hopefully this will be a little bit more light-hearted. So I've been doing this kind of work for 30 years, and I think in some ways, whilst the rules have evolved, in a way, digitalization of the world has created a mini revolution. The way we approach collision cases these days as maritime solicitors is radically different from yesteryear. And it's worth looking back over time to understand where we've come to and where we're likely to head. So looking at historically the casualty investigation and then trial and preparation for trial. So historically, the call would come in, a collision has occurred, and the casualty investigator with his passport in his pocket already would jump on the plane to wherever he had to be scrambled to, get on board the ship. He's really got no idea how the collision has occurred. Sit down with some preliminary talks with the master and the officer of the watch and get a general overview of what's happened. And then he'd go and collect from the ship all of the relevant contemporaneous evidence, because that contemporaneous evidence is what has to underpin the statements. And then once he's analysed that statement, sit down with the crew and very much work with the crew to piece together how the collision occurred. And that evidence, and this is not an exhaustive list, but would include the working chart, deck logs, engine logs, rough logs, radio logs, passage plan, my favourite deck bell book and engine bell book, because the poor chap in the engine room had no idea he was about to hit the collision. So what he recorded is probably more likely to be accurate than anybody else. GPS logs, engine alarm printouts, course recorders, echo trace, tidal data, pilot book, turning circle data, crash stopper data. I've had witnesses tell me they were going full astern for 6 minutes before the collision, but if they go full astern from full speed ahead for 4 minutes, they start going backwards thereafter. So all of this information had to be assimilated by the casualty investigator before he sits down then with the crew, and then working with the crew's fallible memory, he had to piece together what had happened. And the purpose of those crew statements was very much to shape a credible narrative, dare I say it, story, because anybody who's been on board and worked with the crew know that they don't come out as articulate as the crew statements are, telling you about what's happened. And so you really have to work with them to come up with this credible story about how two ships came to meet in the same place at the same time, because frankly, that's the essence of the collision. And to be credible, because you knew later on your story was going to be tested by counsel in a court of law, it had to fit with all of the contemporaneous evidence, which is why you had to work that contemporaneous evidence on board. And it must be possible to distill that story into a plot. The plot was the kind of magic thing you were aiming for as the casualty investigator. I was always told that if you can't make a plot, don't leave the ship. And it would take sometimes up to 3, 4, 5 days working with crews whose English was not that great, whose recollection, sometimes the ship had sunk and you were in hotel rooms with no ship's documents at all. Sometimes that made it a little bit easier. And you would produce a plot. Here's the plot that was produced in the Fushan-Hai collision with the Gdynia. The Fushan-Hai sank, $30 million worth of loss. This was before there was any digitalization. And it's very simple. All of that work to produce one, and it was on a piece of graph paper, one graph sheet, and that at trial would be the key document, and there would be a battle of the plots. And whereas these days you might exchange electronic track data, in the old days at an early WP meeting, you would exchange your plots and see how closely they resembled each other. And then at the trial, of course, the witness statement and the plot form the basis of the pleading for the preliminary act. As Mark had said, the junior counsel, as we now know, would sit there with the witness statement, making sure everything fitted together. But evidence in collision cases was like shifting sands, and inconsistencies would arise out of the competing stories of both vessels. And so given this, it was prudent to keep your powder dry on the pleading section. You wanted to be able to be able to move your case, mold it and evolve your legal case as the evidence tumbled out in trial. And that's why we had the kitchen sink approach, no particularity and all of the rules named, so that you could keep your powder dry. That was the historical approach. And that's why I think in yesteryear, collision claims were so much fun. Digitalization ruined all of our fun, because now the casualty investigation starts with the plot. So before, the end result of all of your labor was the plot, but now you can very easily put together a plot using AIS data from shore sources or the vessel, and you understand now how the collision occurred. You now know how two ships came to meet in the same place at the same time. And the plots can be produced before you go on board, and they will be extraordinarily accurate. Nigel Jacobs will recognize this as the MSC Prestige collision with the Samco Europe. This was the plot produced by his side. They passed it across to us. We overlaid it on our plot, and they fitted like a glove. There was no difference at all. And in fact, this was an interesting case because in many ways, it was a case where the evidence was gathered before anybody had understood what a treasure trove of information there was locked up in this digital data. So in fact, the witness statements for the Samco Europe were horrendous, but it didn't matter because the digital data was able to explain exactly how the two ships came to meet in the same place at the same time. And I say they were horrendous because they had the classic observations of the crew looking out at the other side, the other vessel, 20 degrees off the starboard bow, clearly displaying its red port light, when in fact, according to the AIS, which was incontrovertible, it was displaying its green starboard light. So we knew that the statements were no good. And indeed, in that case, we got to trial and neither party called their officer of the watches. It was a $50 million collision case with no witnesses at all. We went straight from opening to closing submissions because everyone realized witness testimony wasn't going to help their case. And we knew how the collision occurred. And indeed, sometimes you don't even have to do the work yourself. The Delft-Gdansk collision with the BBC Neptune was posted on the G-Captain website the next day in full animation. And if you want to see it, you can still see it on YouTube. But it was available within 24 hours. And frankly, when you see that animation, you know within 10, 15, maximum 20% what the apportionment of liability is. You're really then talking about narrowing down that apportionment. So the casualty investigation, the task's now very different. The casualty investigator goes on board, he knows how the collision occurs, and he's trying to understand a better understanding of why it occurred. He's not saying to the officer of the watch, When did you first see the other ship? When did you alter to starboard? It's when you altered to starboard at C-15, what were you thinking? And then from that, you try and create a story that's going to help your case. Well, why are the crew interviews still important if you know how the collision occurred? Well, I think they're still important because, of course, as Mark touched on, the apportionment of liability is about assessing the proportion of each side's faults. And that assessment requires the weighing of culpability and causative potency of the respective faults. So it may well be that from the plot, you can identify the faults, but there may be valid reasons why certain navigational decisions were made which go to culpability, either to make one ship more culpable or to make another ship less culpable. To take extremes examples, if the officer of the watch has a medical blackout at a critical time with no medical history, then obviously and for example, he's the stand-on vessel, the failure to take avoiding action thereafter will be looked at quite differently from an officer of the watch who is fit, healthy, but not paying much attention. I mean, incidentally, in terms of the audio mics on the VDR, they often give you a real clue as to how attentive bridge teams are. In the MSC Prestige, I think the Samco Europe were listening to Tracy Chapman's I've Got a Fast Car, whilst on board the Samco Europe, they were debating the various benefits of malt whiskey, single or blended. So the real utility of crew statements going forward, it seems to me, will be not so much to tell the story and explain how the collision occurred, but rather to provide important context to the navigational decisions or omissions that were made very much with culpability in mind. And because of all of this now, the digitalization, the key factual and legal issues ought to emerge now from the pleadings. There's no real reason why the parties ought not to be required to pin their colours to the mast, because now we know what happened. In the past, in yesteryear, we couldn't be sure we knew what happened because we'd worked with the crew, but we couldn't be sure that the crew themselves understood what happened. I think when it comes to the trial prep now, you'll have had the collision statement of case, you'll have pleaded your claim, defence, reply, you will have a clear understanding of what the issues are. And I think that trial preparation will change because in most collision cases, there are faults on both sides if we're talking about open sea collisions. And sometimes it's very difficult to make your officer of the watch less culpable than the facts on the plot would suggest. And if it's not helping on culpability, then it's really not advancing your case to put in a witness statement. So only where your case can be improved is it likely that witness statements will go in. And of course, we must also remember that the rules on the witness statement, as Mark has touched upon, had also changed to become more focused. They only now should set out relevant matters of fact that the witness had personal knowledge of and identify what documents, and documents will include AIS and DDR, the witness has been referred to or seen in making the statement. So the old style witness statement used to take up a full day to write up the glorious pieces of work about your career and the officer of the watch, standing the watches and the machinery you had on board and the turning circle data and everything else. About 10 pages before you actually got to the collision. Then you would leave port, your drafts on departure, all of that stuff. You don't need any of that now. You don't need any of that. You will simply focus on what issues are emerge from the pleadings, and if your witness evidence can assist the court in determining those issues. So in conclusion, it seems to me that the new procedural rules reflect now that we know what happened in the vast majority of cases. Digital data has washed away the evidential shifting sands that made collision cases an art form in yesteryear and so much fun. The fun's gone. They've been gone for a long time. Justice, which is really what this is all about, is now best served by requiring the parties to plead out their case with the same degree of particularity as applies in other cases. There's no longer any excuse for us to be able to adopt the kitchen sink approach and hold everything back. We know what the evidence tells us. So there will be no more or much less ambush at trial. Thank you. Over to Alex.
Thank you, Darryl. Okay, so before I start, just maybe for those that don't have as much experience, to set the scene slightly, although looking around the room, there's a tremendous amount of experience here. But in an admiralty claim, in a collision claim, it's basically a split trial. So you end up dealing with the liability on one side and the quantum on the other. And the quantum is generally very straightforward, or it can be quite involved, but it's generally a straightforward thing to deal with. And it's very, very rare for that to get to court. So generally you are just talking about the liability, you know, what's the fault here? So the question is, well, why is that so difficult? Why have we kind of got to go to this big procedure? But it's because this procedure really has to deal with just such a big array of different types of collisions. So you can start off with a collision where basically you've got a vessel that's tied up and another vessel just comes slamming into it, and you've got, you know, straightforward liability case. Or you can go over to the sort of the Alexander, Panama Alexander, where you've got seven vessels involved in a pile-up in a canal. So you need this procedure to basically deal with this, you know, this big array of different types of claims you can get, and also anchor claims. You know, you can have a claim where a vessel sat at anchor and gets hit by another vessel dragging. So all of these types of collisions, if you like, are very different. And you can also get collisions where there's no actual contact between two vessels. So it really does have to take into a very, very wide array of different types of cases. Another point I'd like to make, and it comes into this, to some of the snags that we will probably run into, is that you have the procedural rules for the court, is that you have the CPR and their practice directions, which basically give you the rules of how the court operates and how you have to behave in court and what you have to do. And then you also have the commercial court guide and the Admiralty Court guide. And that's, as the name suggests, a guide that kind of tags onto the side of that and gives some further details about what you must do. So you've got two different documents basically telling you what to do. Okay, so in terms of the changes, well, what are the basic changes? So you've got five changes essentially there. You've got the more certain exchange of electronic track data before the collision statements of case, and that's quite clear. I think we've covered that in some detail. You've got the extra questions, you've got the greater particularity, you've got the requirement for a defence, and you've got the plots. So what's the position in relation to all of those with the procedure? Well, the first four of those are dealt with in the civil procedure rules. And that's what Mark went through earlier, basically going through what the civil procedure rules changes have been made. There haven't been any changes to the guide. So one of the issues we're going to have is that there's a conflict between some of the things that are said in the civil procedure rules versus what's said in the guide. And if you're like a trainee solicitor, like trying to work out what the next procedure is and what you need to do, can you imagine like sitting down, reading CPR, reading the practice direction, and then reading the guide, and then they say two different things? You think, how on earth am I going to deal with that? So there is a potential problem there. Plots isn't dealt with in the CPR directly. There is some reference to it, but there's not an actual reference to when you're supposed to have produced that plot. So in terms of the electronic track data, I think the position now is quite clear, that if anybody's got electronic track data, then that needs to be exchanged before you do the collision statements of case, so that you've got the information to allow you to particularize the position. So I think that's been done, and that's quite clear. It's quite clear in the CPR, but it's not clear in the guide, because the guide still says what the old position was, that you're only going to have exchange of that information if both parties are in possession of that track data. So there's some confusion that could arise there, particularly for younger lawyers that have to get to grips with all of the rules. Plots. Now, in the guide, basically it says that the plot has to be given with the skeleton arguments. So basically right before you're going into trial. Whereas the current position is that when it's discussed between the ASG and the ABG, basically we thought the best thing to do was to bring that in at the case management information sheet stage. So just before the CMC, each side should put in their own plot. And that's not dealt with in the CPR. And currently the guide says that it should be done along with the skeleton argument. So there's a slight problem there. The plots is actually mentioned in the CPR because there is a fast track procedure. So for cases where there is some electronic track data, which Mark mentions is probably in most cases, then the court has to have in mind this fast track procedure. And one of the things they have to do is basically say that there has to be a memorandum produced between the parties as to what you agree on, and see whether or not you can agree a plot. But that's not a sort of a mandatory step. That's something that the court should have in mind. So I think the changes that we're proposing to, hopefully to the guide, that it should be with the case management information sheet, will just bring that forward and just remind everybody that we really want to be dealing with that earlier on at the CMC. Okay, so as I've said, there is this conflict between the CPR and the guide. So how do you deal with that? And basically these two quotes here tell you what the position is. So basically in the first quote there, the underlined section where it says, it does not constrain the scope of the judge's discretion under the CPR on practice directions, but it does include guidance on the approach commonly taken to the exercise of some of those discretions. So it's quite clear that it doesn't undermine the court's powers, and it doesn't really undermine the CPR. And then at the second quote there, the guide must be followed in the Admiralty Court, must be followed in the Admiralty Court, unless the content of Part 61, Part 60, Practice Direction 61 require otherwise. So it's quite clear if the CPR or the practice direction requires otherwise, which it does, because Mark made sure it does, then legally you know what the position is. But I can see for people actually trying to work out what to do, it's going to be confusing. Right. So were there any missed opportunities? So basically, in terms of electronic track data, did we miss any opportunities there? I don't think so. I think it's now very clear that if any exists, then that has to be exchanged at an early stage, and that will include bridge audio as well, as Mark says. So actually, I think we're getting much closer to where we need to be on that. So that's probably a win. Earlier determination of the plot. Well, if we can sort out the wording in the guide, then I think that's probably been addressed as well. Certainly, there's a good agreement between the ASG and the ABG as to how that's going to work. And then with a greater particularity, that is really the key to the changes. Forcing each side to set out what their claim is, well, we definitely achieved that, I think. So in terms of other opportunities, what could we have looked at? Well, when we started, we were talking about three things: cases which aren't particularly suitable to this sort of procedure, nautical assessors, and the need to commence two different claims. In terms of the non-suitable cases, that was discussed. And basically, I think the position is well, you can't cater for absolutely everything. So where you've got those really complicated cases, you'll end up in the CMC and you'll let the judge sort out how we're going to manage that. But ultimately, we did also feel that it would still be worth doing these collision statements of case and having a defence, even if there are 5 or 6 different parties involved, because that does, again, give you all the issues. and makes it easier in the CMC. However, the reality is that different people commence claims against different parties, and so it's not that straightforward. But I don't think there was a missed opportunity there. I think that's just the reality of some cases are particularly complex. Now, nautical assessors, that was another thing. That was something that I was a bit keen to bring into it, but the decision was taken that we weren't going to look at that. And I have to say, given the amount of time it took and effort that it took to get these changes in, that was probably a good decision. But it is certainly something that I think at some stage, and it may even be that's been looked at the moment, that should be looked at, because the position you have at the moment is the court essentially won't allow any expert evidence. So they go to a nautical assessor, and a nautical assessor is essentially former master mariners and have gone into that role, and the court asks them what the position is. Now, there's the cases today and the ships involved today are, technically more complex, bigger vessels, more equipment on board, etc. So, there is a question mark over, well, how suitable is it to give it to one person who maybe doesn't have the exact experience necessary? And so I'll give you an example. There was a case that was involved in many years ago. Look at Chirag over there. And we basically went around, and the issue was there any fault on the part of our clients? And so we had many master mariners working at the firm. I went and spoke to all the master mariners, about 4 of them, basically asked them what they thought the position was. And each one of them came back with a different answer, really ranging from, don't worry, absolutely fine, through to you haven't got a chance, And actually, one of the master mariners is sitting there, it always reminds me that he had the right answer. But the difficulty is that you ask these different master mariners what they would do, and they have different answers. So it's a lottery when you get to the assessor as to which master mariner, because all of those master mariners could be assessors. So it is a bit of a lottery as to where that's going to end up. And because you can't bring in your own expert evidence, you can't influence that outcome. So I think that is something for the future, but probably the right reason not the right decision not to deal with that now. Okay, and also the need to commence 2 claims. So when you're dealing with collision claims, you always have to. You've obviously got 2 vessels. You always end up commencing 2 claims. So you have 2 claim forms. You have two sets of proceedings, 2 lots of £10,000 to go and start the proceedings. And the issue is always, do we really need to do that? And at the moment, you probably do in order to protect time. And one of the issues was, could you do a counterclaim? Because what you wanted to do was you want to take advantage of the counterclaim and the Limitation Act, where basically a counterclaim, if a counterclaim is brought, for the purpose of time bars, it's essentially backdated to the date that you commence the proceedings. But with collision claims, you didn't have a defence, and the defence was linked to the right to put in a counterclaim. So you only had a right to put in a counterclaim by right if there was a defence. And so there was a bit of concern there that, okay, what if we don't get permission to put one in? We might miss it, and therefore we'd have to both commence proceedings. So there is a defence now. So that's one of the questions. Do we still have to worry about that? Probably we do, because of the Merchant Shipping Act, Section 190. There it basically says that claims involving damage have to be brought within 2 years. So you might fall foul of that as well. But again, that might be an area that we can look at in the future. Okay, but apart from that, I think overall it's a pretty good start. Okay, thanks very much.
Thanks, Alex. Donal.
Thank you, Alex, and thank you, Mr. Justice Baker. It's not for me to be correcting a judge so early in my career, but I'd just like to clarify I will be recapping, not reviewing the decisions. This will be very brief and in accordance with your wishes expressed in the email this morning that we stick to the time limit. I certainly will. Probably expect me to be a bit under. As I said, I am going to be recapping. I don't intend to go into any great discussion. I'm always happy to engage in discussion later on. And given the audience and the content of this presentation, if anybody feels they want to slip away early for a quick drink, I won't be offended. This slot was offered shortly after we agreed that Ince would host this event, and I quickly suspected that it was a token gesture in exchange for us hosting something that Mark was very quick to confirm during our preparatory call last week. But I think it is a meaningful thing because there have been quite a few decisions in the Admiralty Court of late, a lot more than we've seen in the last, on average, the last 10, 15 years. So it is quite an exciting time for Admiralty law. So just to cover briefly what I'm going to talk about, first of all, the ever given, dealing with a preliminary issue, dealing with a salvage matter. I'll then move on to the MSC Flaminia on limitation, the NYK Orpheus, PANAMAX ALEXANDER, and the NYK Falcon, a collision, which will be followed by two more collisions, the WILFORCE, the Western Moscow, and the FNG Sydney, and the MSC Apollo. So starting out with the ever given, as I mentioned, a preliminary issue, a claim brought by Smith as salvors against the vessel's registered owners. Before I start, is there anybody who's not familiar with this case? Didn't think so. Okay, we'll skip the facts. So I think we've all seen the picture of the little digger beavering away at the bow of the Ever Given when she grounded in the Suez Canal, and it'll come as no surprise to anyone, I think, that it wasn't the digger and his noble operator who eventually freed the ship. And indeed, owners engaged with Smith very early on in the matter to seek assistance, so that by the time the vessel was freed, Smith were providing onboard assistance in the form of a salvage team, and also technical assistance from afar, as well as the provision of two large tugs, which I understand were ultimately central to the freeing of the vessel. However, shortly after the vessel was refloated, dispute arose over whether a salvage contract had been concluded, and very quickly Smith commenced an action seeking a salvage award under the terms of the convention and/or under common law. Owners contended that the parties had agreed a contract for Smith's assistance to be provided on commercial terms. However, it was Smith's position that no contract had been concluded. So on the 26th of March, there was an email sent by the vessel's owners to Smith, which effectively recapped the negotiations so far. And I apologize for the formatting of this slide. This was responded to by a representative of Smith. Thank you, and confirm, which is very much appreciated. I shall inform our teams accordingly, and we shall follow up with the drafting of the contract upon receipt of your client's feedback to our draft as sent last night. And the court held that on this basis and by the exchange of emails relied upon by the defendants upon their terms and read objectively and in context, the parties corresponding at the time did not purport to conclude a contract between the parties. The judge was satisfied that agreement was reached on the remuneration terms for a contract that was being negotiated, but that the parties made clear to each other that they were still negotiating and that they did not communicate to each other any intention to be bound by those terms. And salvors are therefore entitled to pursue a claim for salvage under a common law or the convention. And I'm sure we will be seeing and hearing a lot more on that to come. Moving on now to the MSC Flaminia, a case described by one of the judges involved as a tragedy, and indeed it was because 3 crew members perished. And as you can see from the photograph there, the Flaminia involved an explosion and a significant fire, which resulted in damage to the vessel and cargo. This occurred in July 2012 when the vessel was en route from Charleston, Louisiana to Antwerp in Belgium. And the explosion occurred in cargo hold number 4. Upon investigation, it was found that at least one of the 3 tank containers that were being carried on board, loaded with a cargo by the name of divinyl benzene, or DVP, commonly known, had exploded. The vessel at the time was owned by Conti Container Shipyards and was chartered by MSC. And proceedings were commenced in London by way of arbitration, and there were also court proceedings in the US. Following the London arbitration, charterers were held liable to owners to the tune of approximately $200 million. And in July 2020, MSC issued a claim form seeking to limit liability for any claims arising out of the casualty pursuant to the 1976 Convention, the limitation of liability for marine claims, and the 1996 Protocol, which of course is enacted under English law, the Merchant Shipping Act 1995. They also set up a limitation fund of £28 million by way of an LOU provided by their United Club. Excuse me. The question asked of the court was whether MSC's liability to Conti was subject to limitation under Article 2.1 of the Convention. And MSC argued that the damage to the Flaminia was caused by the loss of or damage to the DVB that exploded, and that Conti's claim was therefore in respect of consequential loss resulting from non-ship property. This is important because under English law, Article 2.1a covers only claims in respect of loss or damage to property other than the ship. And that comes from the CMA Jakarta, a Court of Appeal decision from 2004. That argument was rejected by the court, well, that owner's claim against the charterers was a claim for damage to the ship and consequential losses arising from that damage, not a claim for loss or damage to property other than the ship itself. The judgment contains some helpful guidance about the proper interpretation of Article 2 of the Convention, and I understand that this decision is pending appeal this summer. So once again, we can expect to hear more from this from the Court of Appeal later this year. Next, on to a collision, which hopefully will play here. This is the Suez Canal. You're watching a northbound ship there, but it's just about to pass a ship on the western banks of the canal. And the more eagle-eyed amongst you will have copped on that the ship shouldn't be there if it's transiting the canal. It is in fact moored. It's the Panamax Alexander, which suffered a collision the day previously involving 4 other vessels. And the vessel is moored there with the intention of it being moved to the Biller Lakes later that day. You'll see one ship has passed. The second ship also passed. However, it wasn't broadcasting AIS. Enter NYK Falcon, which passed at considerable speed, 6 knots, dropping down to 5 by the time it reached the vessel, and then 4.5. And in a moment, you'll see the Panamax Alexander shudder slightly as the NYK Orpheus appears from the south. And eventually, the NYK Alexander breaks free of her moorings, and the Orpheus crashes it to her. Now, the Alexander was secured with a total of 6 mooring lines. That was 3 forward and 3 aft, although there were tugs in attendance. But it appeared that the master had effectively deferred to the judgment of the pilots and the Suez Canal Authority in mooring his vessel. And it was held that, the nautical assessors agreed that no reasonable master of a vessel that size and that position would be satisfied with just 3 mooring lines forward and aft. And that, of course, is why the vessel did ultimately break free of her moorings. Of the Falcon's passing, it was described by the judge as clumsy and ill-judged, largely to do with her speed and the ill decision on board as to their refusal to slow down early enough so to pass at a safe speed. And this was contributory to the Panamax Alexander breaking free from her moorings. The judge was satisfied that both the Alexander and the Orpheus reacted poorly to the situation. In particular, the Orpheus, there was a lot of indecision on the bridge in slowing down the vessel, but was also satisfied that because of the angle of impact, the position of the Alexander when struck by the Orpheus, that significant damage was inevitable once the vessels did make contact. It was held that the Alexander and Orpheus were equally to blame, and that they were both more than twice as much to blame as the Falcon, and therefore liability was apportioned in the proportion of 5-5-2. The judgment contains some interesting comments on pilots. Excuse me. And the mariners here amongst us will be well familiar with the Suez Canal. I've transited over a dozen times. And the Suez Canal pilots are not known for their diplomacy. I don't know their fee structure, their salary arrangements, but I'm fairly sure they're not paid by the hour because they always seem to be in a hurry to get from A to B. And faster, faster is regularly heard. Slower, slower is something I've yet to hear a Suez Canal pilot say. But they can be difficult to work with, and there is a degree of sympathy to any master who has to work with a Suez Canal pilot under these circumstances. But that does not relieve the master, of course, from any obligation in terms of the safety of his vessel and the safety of navigation of the vessel. Next, a collision involving two vessels in the Singapore Straits. The WILFORCE, seen here in blue, was navigating in the northeast. Apologies to my colleagues. Actually, I should have thought about this and arranged a screen in front of you guys. The WILFORCE in blue, seen here in the northeastbound lane, and the Western Moscow in red coming from the northeast there. The vessels were transiting the Singapore, vessels transiting the Singapore Straits, and they were navigating in this precautionary area, which I'm afraid it is difficult. I think we can use the pointer. Doesn't work. Anyway, where you can see that red loop is a precautionary area. Now, this is, as the name suggests, an area where vessels should exercise a greater degree of caution because of usually an expected high volume of traffic in the area, or an area where traffic converges, or there will be a lot of crossing traffic. They're not dealt with specifically in the rules as under Rule 10 for TSS, but they are there and they are something to be considered. And because they were navigating in Singaporean waters, the vessels were further required to comply with the rules for vessels navigating through the Straits of Malacca and Singapore, which state, inter alia, that vessels should proceed at maximum state of manoeuvring and readiness in these areas, and also that they shall maintain at all time safe speed consistent with safe navigation, and shall proceed with caution, and shall be in a maximum state of manoeuvring readiness. There's also a requirement that they use the VHF and that they engage in VHF communication, particularly with the VTIS, the Vessel Traffic Information System in Singapore. Now at C-10, and apologies, the pointer doesn't work on the screen, but somewhere early on in that blue plot, 10 minutes before the collision, the WILFORCE altered course slightly to port. So that is somewhere around here. And the reason being is this green plot here was a tug and tow coming down from the north. And it was her intention to point the bow effectively at the stern of the tow to make sure that she was going to clear astern of that tug and tow. Now, at around the same time, the Western Moscow was making a heading of about 128 degrees. So it was somewhere around this position here. And Western Moscow's intention was to loop around. The intention was always to enter the southwestbound lane, but it crossed and now intended to loop around to make her approach to the southwestbound lane. At C-7, the VTIS, the traffic control service, called WILFORCE to alert her of the presence of Western Moscow. And at around the same time, there was a CPA, a closest point of approach alarm on board WILFORCE for Western Moscow. So the master of WILFORCE very much aware of the presence of Western Moscow at this point. However, at C-4, 3 minutes later, WILFORCE was still on full ahead, although they reduced speed around this time from 69 to 61 RPM. However, this was still within the region of full ahead. And so the vessel's engines are not ready for immediate maneuver as required by the local rules. At this time, C-4, the VTS instructed WILFORCE to take early action and reminded them again the presence of Western Moscow on their starboard bow, and pointed out that the vessel, that Western Moscow had intended to enter the southwestbound lane. Sometime around now, there was an agreement by the vessel, by Western Moscow and WILFORCE, that they would pass port to port. And so WILFORCE started coming to starboard to follow the tug and tow, and in order to get astern of the Western Moscow. And you can see this is a point here where the heading is changing slightly to try and get around the tug and tow, and also meet the obligation to pass port to port, or the agreement to pass port to port with the Western Moscow. But by C-2, 2 minutes before the collision, WILFORCE was only down to 51 RPM, and that is still also full ahead. So that by C-1, she was still doing 13.9 knots. And at this point, she put her engines full astern. I was held that before C-7, there was no risk of collision, that the risk of collision was brought about by the poor lookout on Western Moscow. And this poor lookout was exacerbated by the fact that at or between C-3 and C-2, those on her bridge seemed to be confused as to the appropriate action to take, even though they had agreed to pass port to port. And as a result, Western Moscow delayed applying hard starboard helm in order to check that turn to port. It was found by the nautical assessors, and I believe it was asserted by by counsel for WILFORCE, that had the vessel steadied on a course of 350, 355, which would have been optimal to cross that, to get out of that northeastbound lane and cross the TSS and then enter the southwestbound lane, that the collision could have been prevented. But WILFORCE was heavily criticised for continuing at over 15 knots until C-2.5, and thereby reducing the space available for effective use of the starboard helm when the tug and tow permitted such action. So effectively, that if WILFORCE had slowed down earlier, she would have had a lot more time. And this is made quite clear in the rules that if you're concerned about the movements of a vessel or you need more time, you should reduce engine speed. And so it was held by the court that liability should be apportioned 75-25 in favor of WILFORCE. WILFORCE herself being criticised for her speed, and in a poor look at. And finally, FMG Sydney, MSC Apollo, one of the more recent decisions, and the rarest of all beasts, a 100-0 apportionment. The collision occurred off Tianjin. I'll just skip straight to the plot. FMG Sydney, seen in blue here, was departing the port together with a number of other vessels, the Chafa Long in green to the south and 2 other vessels to the north. And at the same time, the MSC Apollo in red was approaching the port with the intention of anchoring somewhere to the southwest down there. So these plots originate from approximately C-6. At around C-11.5, Apollo triggered the AIS alarm on Sydney's X-band radar. And upon viewing the situation or observing the situation, the master of FMG Sydney assessed that the MSC Apollo would pass to her stern. At that time, she was looking at the 2 headlights of MSC Apollo. So effectively, the MSC Sydney, from where she was looking straight down the bow of MSC Apollo. And because of the relative movement of each vessel, the master expected the MSC Apollo to pass astern of the FMG Sydney. But because of later manoeuvres by the MSC Apollo, that changed, and eventually the master and FMG Sydney assessed that the MSC Apollo would pass ahead of her. The MSC Apollo, on board the MSC Apollo, there was a misinterpretation of the situation from the off, and it was assessed by the master of MSC Apollo that they were always going to pass of FMG Sydney. And that is why the vessel MSC Apollo, as I think it was in the judgment, the word nibbling was used, that she nibbles to port. And the rules require that in a situation where there is a stand-on vessel and a giveaway vessel, this I should clarify, under Rule 15, the crossing rule, FMG Sydney being the stand-on vessel, MSC Apollo the giveaway vessel, that the giveaway vessel take early and effective action to avoid collision. And I think the use of the word nibbling is to clarify that this was not effective action. And there's also a requirement in the rules that the action taken should be broad enough to be readily apparent to any other vessel observing either visually or by radar. Again, something that was not complied with here. Although not pleaded, there is an obligation by the stand-on vessel to take action. There is an option for the stand-on vessel, must or is required by the rules to maintain her course and speed. And there is an option under Rule 17A2 for that stand-on vessel to take action if she becomes concerned with the movements of the giveaway vessel. And under 17B, there is a requirement for the stand-on vessel to take action. However, that action is severely limited by the rules and also limited by the presence of the other vessels around. And in this case, in particular, the Chang Fa Long precluded the FMG Sydney from taking action in the form of a broad alteration of course to starboard, which is always the preferred course of action when you find yourself in a situation like this with a giveaway vessel on your port bow that is not taking appropriate action. Fault was found on the part of, fault was alleged on the part of FMG Sydney in respect of her lookout and her speed. However, there was no causative fault found, which is why the apportionment was 100 nil. Interestingly enough, there was an allegation by Apollo that the FMG Sydney, because at one point could view the Apollo right ahead, could see both her sidelights, that there was a head-on situation. Now, this didn't get very far with the court. And personally speaking, and this is the only personal remark I'll make, as a mariner, I think it's slightly unfair to suggest that a master on board a ship faced with not just one vessel, but a number of other vessels that they are in their proximity should stand back and look at the rules and think, hang on a minute, just because this matches one line in one particular rule that I don't think, do I need to think about as to whether or not I should be applying this head-on rule when I think it's a crossing situation. So I think the point I'm trying to make there is that we decide, the legal practitioners decide these with some of the finest minds in the world. I think it's a little unfair. We train our sailors in the rules. We give them these rules and we say, here you go, out you go and drive your ship. I've never, before I came ashore, I've never come across any legal concept or any legal debate in terms of the rules. And so I think it's a little unfair that there might be a suggestion that a master should have thought that this could be a head-on situation, particularly given the circumstances at the time. And that's all from me. Sorry, I got a bit muddled at the end, but if there's any questions, as I said, I would love to discuss any of this afterwards, but I will leave you now and give it a hand. Thank you.
Thank you. So I'm acutely aware that I'm all that stands between you and a glass of wine, which is not a great place to be. And I also bear in mind the admonishment from our chairperson directed at me in particular before we started. Not the first time a judge has told me to put a sock in it, but usually they wait for me to start speaking before they do. I'll be brief. What I'm going to have to say to you is nothing to do with any of this fascinating stuff about collisions and plots and who does what and goes where, which reminds me a bit of doing physics at school, which I was never very good at. So I was just stare open-mouthed in admiration for all the people who can understand this stuff. What I'm going to talk to you about is personal injury and fatal accident claims, and only those claims. So nothing I say has any relevance to any of the fascinating stuff that these guys do. It's just personal injury and fatal accident. And there's been one change to the rule, but a really, really important one in relation to where you start those types of claims. Now, when I started at the bar, back when dinosaurs roamed the earth, as my daughter would say, we issued low-value personal injury and fatal accident claims in the county court. We issued high-value personal injury and fatal accident claims in the High Court. And if they involved boats, water, or anything of that nature, we issued them in the Admiralty Court. And that, for a while, was the happy way that practitioners muddled along. Then somebody, this has got to be about 10, 15 years ago, somebody read the Senior Courts Act for the first time. So it had been in force for 25 years at that point. So the new act, somebody actually had a look at the provisions of it, and it appeared to that particular solicitor, it was actually one solicitor who started this, it appeared to that solicitor that the Senior Courts Act required that if you wanted to issue a claim that arose out of a personal injury or fatal accident claim, and if it involved a ship, then you had to issue it out of the Admiralty Court. And there was no discretion to issue small value claims out of the county courts. If you did issue a small value claim out of the county court, or any claim out of the county courts, it had to be either struck out or sent up to the Admiralty Courts. And so what happened following that sort of realization, that light bulb moment, this is about 10 or 15 years ago, as I say, is that people had to start issuing out of the Admiralty Court, no matter the value of the claim. And it meant that you might get what we've been calling hotel claims. So the type of claim that arises from cruise ships. Mrs. Miggins drinks too much and falls down the stairs. Somebody gets a dicky tummy from eating some shrimp salad. Norovirus claims. They were all being issued out of the Admiralty Court, no matter what the value was. If you issued one, you might get a claim for £2,000 for food poisoning. You might issue it out of the county court, and the defendant would then say, well, you've issued it out of the wrong courts, and would then invite the county court judge to strike it out. Now, invariably, the county court judge would not strike it out, but he would send it up to the Admiralty Court, which would then send it back down to the county courts. Now, we spent a happy decade doing this, and it paid my mortgage. But what it did was that the Admiralty Registrar, before he started all of this fascinating stuff of his day, had to wade through a tidal wave of diarrhea and vomiting and norovirus claims and God knows what before he got to the stuff which actually has a sort of nautical feel to it. So for some reason, the Admiralty Registrar decided that that wasn't a great use of time in the Admiralty Courts, and plans for not paying my mortgage anymore came to fruition. So the Admiralty Court Users Committee then considered a change to the rules, and this is what we've got. It's at the back of the handout. This is not my own work. I pinched it from a colleague, actually. It's an article which was prospective rather than retrospective. So it was an article which my colleague Tom Collins wrote just before the rule change came to fruition. But it sets out what the old rule used to be and what the problem was, and then it sets out what the new rule is. So the thinking behind this is effectively, well, if you've got a hotel type claim, you don't really need the Admiralty Court to be thinking about that, because the Admiralty Court is in no better a position to think about hotel claims than the county court is, because the county court considers Mrs. Miggins falling down the stairs all the time. And if you've got a claim that's worth £1,000, it's just not worth issuing in the Admiralty Courts. There were issues of proportionality, there were issues around the fixed cost regime, things like that. Defendants didn't like it. Claimants didn't like it either, because if you were a high street firm and you hadn't heard about this issue, you ended up going from the county courts to the High Court and then back down again. It was a complete waste of time and money. So what we've got now is a rule change that allows for some discretion, allows for some kind of movement on that. Where you've got a personal injury or fatal accident claim which arises out of a collision or an action in rem, you issue it out of the Admiralty Court. So you must do that. So you carry on doing that, that's fine. Where you've got something that has what I would describe as a nautical flavour to it, you also issue it out of the Admiralty Courts. Where you've got what I would call a bog standard hotel claim, so Mrs. Miggins falls down the stairs, you issue it out of the county courts. And there is guidance in the practice direction, non-exhaustive list of the type of claims that the Admiralty Court might look favourably on you issuing out of the Admiralty Court, because there is either a need for or a desirability of the Admiralty Court thinking about those claims. These are the type of claims that involve sea state. So that's something where the Admiralty Court might be looking to bring some expertise to bear on it. Type of claim that involves members of the crew. things like employers' liability claims for crew members, where they're doing something that's specifically nautical. So I've got one at the moment where there's a mooring that's gone wrong. And that's the kind of thing that the Admiralty Court would have a specific expertise in that the county court judges might not see so often. So it's something that you can see is well suited to being issued out of the county courts. Things like collisions, shipwrecks, explosions on board, things where there is an area where the Admiralty Court has seen lots of it before and is likely to see lots of it again, whereas your average district judge in Birmingham is going to see less of that type of stuff. So these type of cases are the types of ones that need issuing out of the Admiralty Court. Also claims which are going to raise difficult points under the Athens Convention, because obviously the Admiralty Court's got a specific expertise in that. So where you're looking to interpret the convention as regards, let's say, defect in a ship, or you're looking at various difficult points of limitation regimes under the convention and other limitation regimes, or international law regimes, so sort of American maritime law, then you would issue out of the Admiralty Court, because again, they've got that specific expertise. They're better able to deal with that than your average deputy district judge, for example. So we've gone from a blanket, you must issue all claims under the water out of the Admiralty Court, to something which is a bit more nuanced. And as a barrister, I love nuance. It means that we get to advise more, it means there's more uncertainty, it means that things go wrong more often, which is always good for us. But it actually, in this case, is designed to help practitioners and designed to avoid this slightly odd situation where you went up, you came down again, and you were 9 months on with no further forwards on your claim. So it is designed to make things easier for you. I hope that's relatively brief canter through. Again, I'm very happy to answer questions if need be at the end.
Thank you, Sarah, and all of our speakers. I'm not going to resist the opportunity of being chair just to pick up myself one or 2 points. One thing that Sarah has just said, and also there's something else about that reform, and a couple of points that Alex made before throwing the floor open more generally, if there are questions that you'd like to raise before we adjourn for refreshments. Firstly, in relation to what Sarah has just been addressing, one of the, I was about to say unsung heroes, but you sing his praises often enough. He's perhaps a sung hero of the Admiralty Court, is our Admiralty Registrar, Master Davis, and I won't spare his blushes because he is here, and he deserves, if I may say so, the credit of initiating membership on the Users Committee of Sarah, effectively as representative of that important section of the practitioner community who have the experience and expertise in that field of claim, which is still going to be an important area of litigation for the Admiralty Court, albeit now properly limited to those personal injury and fatal accident claims that really require the expertise of the court. So I thank them both for their contribution on that. The one, if it gets as far as being a slight correction, I would make to something that Sarah said, but it's only to emphasize the importance, I think, of the reform we've introduced, is that she did say invariably the district judge or deputy district judge would send it up only for Master Davison to send it back down again. Not actually quite so. Very occasionally, they acceded to the submission that this was a jurisdictional problem and the case was struck out, and a potentially perfectly meritorious, at least meritorious enough to deserve its day in court, small or medium value personal injury claim would find that they'd been struck out. Perhaps they would then be time barred to start again in the Admiralty Court, and that point hadn't been addressed to the County Court, or they had just then been, frankly, as will happen with smaller value litigation, put off pursuing justice. So, albeit in only a small number of claims it might be over any given period of time, I do think that's been an important contribution that we've been able to make, again, through the work of the Users Committee, which I won't say gives me a fast track in, but certainly has a track record of success before the Civil Procedure Rules Committee, partly because of the quality of the papers that they allow me, because they do all the drafting work and I then just get to sign off, am able to present CPRC for proposed reform. Then in relation to Alex's, only one observation by way of attempted small joke, that he suggested that the 100 nil apportionment was that rarest of beasts. Well, if it is a rare beast, it's like the London bus. Viz, you hardly ever see them, but then all of a sudden you get two in a row, because the Panamax Alexander, she who was moored to the side before the Falcon came past, as I held a little clumsily, before the Orpheus then ran into her, was, according to my predecessor, Miss Justice Tier, as he was, 100% at fault for the collision that had put her moored to the side of the canal in the first place the previous evening. More seriously, Alex raises a correct observation about the guide, and speaking both as the Admiralty judge that has had responsibility, who has had responsibility for these rule changes, and as the principal editor of the 11th edition of the Commercial Court Guide, incorporating the Admiralty Court Guide that is, relatively speaking, still hot off the press. He's absolutely right to say that, of course, our reforms have come in a few months after the new edition of the guide, and we do not have, deliberately so, a practice of annual updates, supplements, or revisions to the Commercial Court Guide. And so that is something that I say now to all of them present, because I think most of the Users Committee pretty much is in the room. We do need to put on our agenda as a Users Committee to identify those areas of the guide in respect of which we ought to be saying something, or rather the Users Committee ought to be encouraging me, or me jointly with Master Davison, to say something, and between now and whenever the next edition of the guide comes out. And thank you for that reminder. It probably is worth some species of practice guidance or practice note from me, if only to save the anxieties of the junior members of the ASG or ABG suddenly worrying that they should be doing something that is still said in the guide that seems no longer to fit the rules. The rules, of course, will and always should take precedence. So with those few additional observations from me, before I throw it open to question and answer, could I ask you to thank our speakers in the traditional fashion? Thank you all very much. On that note, I think the magic of our technology will be giving those who are viewing us remotely and have still stuck with us to the end a wider angle view of the panel seated. And let us see if we have any questions to which we can attempt an answer. Thank you. Yes. Nigel.
I've got a question about.
So just before you go, particularly for those remotely, whether we need, yes, we probably do need to use the remote mic.
Thank you.
Yes, Nigel Jacob, thank you.
Thanks. I've got a question about the change of the rules under part 2, which require full particulars of 1, the sequence of material events leading up to collision, and all allegations of cause of negligence. So just tell me, can anyone give me an example of what should now be included in part 2, which wasn't included before? And my second point, my second question is, in my experience over the last 4 or 5 years, what has happened in case management audits is that the parties have agreed to exchange what-if plots after the exchange of witness evidence, so they see what's the other side witnesses have said. They've agreed to exchange what-if plots, and then to comment on the what-if plots, to agree the basis of those plots, and to comment on those plots. So those really, in my experience of the last few years, have set out the position in relation to allegations of negligence. So I'm slightly puzzled as to what the A1 is actually getting at, A1 2 is getting at, and how it differs now from what was pleaded before.
Well, I'm going to play the judge's trump card and say that I don't give advice extracurricularly and pass that to
just some examples of what now should be pleaded, having just done one in the last few days.
Yes, quite difficult to come up with a hypothetical story. I think the the fear was that the information that's on part one allows you to piece together most of what you might call the narrative of the build-up to the collision. But a lot of that information is, well, by the nature of part one, is compartmentalized in various different bits. Well, so you've got pieces of jigsaw. So the thinking behind it was to set out, as you would in a pleading, nothing to do with collisions at all. In a negligence case, nothing to do with that. Is elements of narrative in a chronological order, narrative, using some of those bits of jigsaw that then set the scene, as it were, for the allegations of faults and negligence that follow. Does that make sense?
Not with respect, not really.
Not really.
No, so let's give an example of the crossing case. So you've set out what happened in your part one. And what in your part two, you're supposed to say, you know, the crossing rules applied at X, the ship should take an action at C minus whatever it is. You're supposed to go into that detail, because then you're going to have to instruct experts, give you a what if clause at a very early stage before you've had the other side evidence.
Yes, well, I think that's the idea, is to try and move closer to that idea.
But why wasn't that done? That was being done already by the what if clause exchange. That was already being done.
But I think the idea was to try and get the pleadings done. So this is an earlier stage than the what if plots.
But the what if plots are quite difficult to produce until you've seen anything from the other side to explain why they didn't take the action which you're alleging they should have taken.
Yes, that can be levelled in any other case, the leaders out of collision when you're pleading negligence. But you have that same problem because you don't yet have an explanation from the other side, save as to what was in pre-action correspondence. I mean, it's a question of degree, I think.
So you're looking for specific times in part two.
If you could give them, yes.
You can't give them all stuff with what you've got. They should have taken action as the giveaway vessel.
Yes, you may. I mean, it may be that if you stand up the CMC with a collision statement case, it may be. I don't know. That if you stood up to defend a briefer collision statement of case along the lines of pre-April, then you may well be able to defend it if you've got some justification for it. So it's kind of like a change. The rule is a change of expectation as much as anything else.
I think what I would add, listening to that discussion, it is to bear in mind the useful but nonetheless generic and wide-ranging set of information that you have collected at part one. And at the risk of focusing excessively on a single word, the emphasis here then for your part two is what matters. That's what we lawyers mean by talking about the material events. You've got all that basic raw data, and how much of that and in what way is any given party saying actually then matters as regards fault, and how are you suggesting that was causative, so that instead of having a long list in relatively boilerplate fashion of all the things you are thinking you might say they did was not perfect, and which you will then elevate into an allegation of negligence, there is a requirement to focus on what you will be saying as best you are presently able to be advised at the stage of pleading a case. You will be taking to trial as your allegation of causative fault. And without prejudice entirely to any submissions that might be made, if I have to decide any point about it, I don't, for my own part, see why in that respect, you as collision practitioners should plead with lesser particularity than any other practitioner in the law of negligence. If you plead a solicitor's negligence claim, you are expected from the outset to say what they did wrong, when they did it wrong, what they should have done instead, when they should have done it instead, and what difference you said it would have made. And only when you have done that, or provided a compelling justification for being allowed not to do that in the particular circumstance of a particular case, should you be coming to the court to case manage your case, because until you've done that, you've not even defined the case that you wish the court to manage. That's the thinking. Yes, James Turner at the back, we've got the mic.
Sorry to stand up just because I'm very tall. My comment about the changes is this, that in the pollution trials that I've done in the last 6 years or so, which have been 3, the feature that has struck me as not the what if what, which I'm not sure if I've seen before, but is the audio transcript. And all 3 of the cases that I've been involved in have seen points of negligence arise from the audio transcript. Now, preparing the audio transcript is very difficult, very time consuming. If you want full particulars on why it's difficult and time consuming, there's an article that I read that's on the Project Trains website. But the rules permit, I think, a maximum of 4 weeks between the exchange of electronic track data, which includes the audio recordings, and the pleading of the collision statement of case. And that, with the greatest respect, particularly in a 3-vessel collision, and even in a monolingual collision, is simply not enough time to have listened to the 3 or 4 audio channels on the other side's audio recording, have made a transcript of it, and have handed it to, hopefully, counsel for the preparation of the collision statement of case. Now, there's not much I can do about that right now, but my question, which is really one to the Admiralty Registrar, which is fortuitously here, is how readily will the court accept that there should be an extension of time before the filing of the collision statement of case, where the parties are still beavering away, trying to batter the VDR recordings into some semblance of order, because as the judge will confirm, in almost every case now, some very live point of negligence will arise from the audio recording. As was said, the emphasis now is on the why, and the audio recording is a key part of that. So if you want your full particulars, will we get some more time to enable us to keep them?
But before I accept the invitation, which is a novel one, but a very welcome one, I'm sure, to me and the panel, to deflect the Q&A onto another member of the assembly. I shall say, subject to correction from my left or right, I do not remember the alternative suggestion or additional suggestion implicit in your question, James, and articulated in your short piece on the website, being one that we specifically debated as part of the consultation process. Now, I'll leave to others to draw any inference they might as to whether that indicates that it was not a suggestion that was put forward in the consultation process, and whether had it been, it would have been simple. I don't know.
I put it forward.
Why? There we are. Well, others will have to answer for that if that's the fault. I can see, though, that an element of what you said there, and which again is in your piece online, is of real relevance. And that is, as Mark was saying in answer to the differently focused question from Nigel, and as with almost everything in life, there has to be a degree of balance. And as you said, is or can be a very difficult, very time-consuming, and hugely expensive exercise. It raises immediately the question of whether that is an exercise that we ought to be requiring the parties to do before they even have pleaded their cases and worked out how much is really an issue between them, by reference to which they may then wish to engage in such an exercise. As then to your specific question of whether time is likely to be extended for purposes of that exercise being undertaken, I am going to invite you on. I am going to accept your invitation to see if Master Evson has any immediate thoughts, although subject to the same judicial caveat that, of course, he and I are not here to advise, let alone to advise in advance on how we might decide a hypothetical case if it comes in front of us. So that the obvious answer is one would see, but whether he has any particular current steer on his current thinking, I'll invite him to say for himself.
Well, it's a new point, and as Sir Andrew has said, it's not one that we debated, I think, at all. James, in the lengthy preamble to his question, said that the importance of the voice recordings came out in the 3 cases he's done in the last 6 years, 3 collision cases, at trial. And plainly, we can't wait that long to have the case pleaded out. So I think it's going to depend very much on particular circumstances. I would, I think, be sympathetic if there was a basis for saying that the audio recordings were in a particular case going to be very, very central. But of course, there's always the possibility of better particulars being provided further down the line and amendment. And I think it's going to have to be resolved very much on a case-by-case basis. I'm afraid that's not a very definite answer to James's question, but I think it's the best one I can give.
Yes, Richard.
This is really just a point of clarification. Alex, I think, mentioned that the Admiralty Court Users Committee is currently looking at reform of the system of nautical assessors. And we're not currently looking at it. I was at the last meeting and had Martin Walker egging me on to mention it. And I did mention it, but it got you on a cruel response. I thought I would just fill everybody in that Mr. Justice Baker said that well, he would need there to be an expression of support for reform, which went beyond merely a party wishing to have an expert, but there would need to be some voicing of concern as to the fairness of the current system. So I just thought I would put that out there so that maybe there's a voice of support in favour or not. I don't know. I don't have any particular skin in the game, but it's not something current.
Thank you. Thank you, Martin. What Richard Saul has just said is absolutely right as to where we, as a users committee, are at the moment. I would add, since I have this audience to say it too, is that one particular reason for that is that if and so far as particularity has been provided to me so far by way of a voiced concern, it is difficult to know whether there is objective substance to that rather than ultimately an expression of disappointment that a particular result has recently gone a particular way for that firm or firm's client. But also B, it has often tended to be expressed in terms of the sort of concern that Alex mentioned, namely, do we have available to us collectively the right range of expertise, experience, and recent enough real-world experience amongst, and they still are called this, the elder brethren at Trinity House. And that's quite a wide question that is not naturally solved by starting to explore whether the court should abandon a centuries-old tradition of dealing with a particular aspect of expertise. I would encourage, if there is any view out there that it is an issue on which people would like the users committee and ultimately the court to consider a possible change of practice, that you not develop any proposals without going and engaging constructively with Trinity House. If there are real concerns of that kind, go and speak to Trinity House. Find out how and from where they are these days recruiting and populating the Court of Elder Brethren. But to give the most recent example, James Turner, who's already spoken, was in the case, so he'll know that the elder brother in question, a current serving Keanard master of the Keanard Queen Mary. Now, of course, in many respects, an entirely different kind of a ship to a large container ship, but she's almost the same size as James Turner's client's ship, the NYK Falcon, the one that went past slightly clumsily in the Suez Canal, as I held. The Queen Mary transits the Suez Canal at least twice on every long distance cruise. He is a current serving master mariner with current experience, and it won't be any surprise to you that although it was not as such a topic on which I sought their advice, it was not something I had discussed with them. I certainly was given to understand after I produced the judgment that the observations I made about the experience of mariners with pilots in the Suez Canal were on point and were very welcome. And so, for what it is worth, they're in the sort of case where I think there might even have been, Master Davidson will correct me if I'm wrong, but I think there might even have been some suggestion in PANAMAX ALEXANDER #2, when it was before you for case management, but we not use nautical assessors. And you held the line, but I may be confusing my cases. For what it is worth, I regarded the system as working very satisfactorily, and I was provided with a blend of the very experienced General Master Mariner and the subject matter specialist still a currently serving Master Mariner. So there we go. There's a slight monologue there, but simply to say that those who might be wondering if the system could do with being looked at, I would recommend that you not see it in terms of simply you, the solicitors or barristers, coming up with thoughts and coming to the users committee rather than consulting rather more widely as to whether there is a problem, and if there is, whether the solution is reform at our end or dialogue with Trinity House as to how the population of potential nautical assessors is created and refreshed. So James again.
Sorry, but just on the topic of master mariners, I think the experience can be very variable, and nautical assessors, one you've referred to in the NYK Falcon, yes, he was excellent. I have, in other cases, had a nautical assessor tell me that's not an AIS symbol when it clearly was, and that sort of lack of current knowledge is then very unfortunate, indeed. To take another case where your predecessor wished he had had a nautical assessor, the Ocean Victory. That was on the nautical side of it at trial. The issue was the control of a Cape-size bulk carrier in the teeth of a Force 10 or Force 11 storm, which is a very particular experience that very likely nobody at Trinity House has, or if they had, then you would have to dig quite hard to find them. And then, of course, hope that the other side was handled with that choice. But I mean, that was not a piece of seamanship that was capable of resolution by anybody who didn't have that very specific experience of handling that size ship in those weather conditions.
Well, David, I mean, for today's purposes, not least because of the time and the fact that we should be wrapping up, I would leave with the thought that we are a small enough community of professionals in to use what might be the modern jargon, this litigation space of web shipping litigation, you have a very active and well represented users committee that liaises with me and the Admiralty registrar. And on topics of that kind, I would very much hope that we would, through that process, always be open to engage in dialogue. But it probably does suggest that if there is to be any serious call for that to be looked at, the dialogue needs to include Trinity House as well. And if that's a prompt for introductions to be made, or if you need them, or in any minute the ASG or the APG to make approaches to discuss some of these things at that general level of fitness for purpose of system rather than the discussion of individual cases, I would like to think that our colleagues at Trinity House would welcome those discussions.
Well, Sir Andrew and our panelists, thank you very much for bringing us right bang up to date this evening with the recent developments in the rules and also the recent cases. It's obviously been a busy and active couple of years, I think, in the Admiralty Court, as has been repaid this evening. I'd also like to thank, as well as our chairman and our panel, the London Shipping Law Centre, and also the Ince team who've helped put this together tonight, Sarah and Joe and Sri as well, and Darren as well, if I'm not sure if he's still here, but if not, thank you very much to all of them for working tirelessly and quietly behind the scenes to pull all the technology together to make it go off, I think, seamlessly. Thank you very much to all of them, and thank you to all of you for turning up this evening. Gerard told me earlier that this was the first time for a long time we've actually had more people here in the room than have been online. So maybe the pendulum swing back to doing more of these events in person, which is certainly something I think I would personally welcome. But so thank you to all of you as well. And without more ado, let's adjourn now. And please do join us for some drinks afterwards. Thank you. Just quickly before I do, next event is on the 13th of June, when we'll be changing tack to be talking about misdelivery and letters of indemnity. And that's going to be hosted, I think, by Quadrant Chambers in conjunction with the London Shipping Law Centre. So I look forward to seeing you there. Thank you.